I'm going to call names. Please say present or here so I can acknowledge you for the docket. April Grant. April Marie Grant. Michael Sanders. All right, I'll call you back in just a moment. Nathaniel Whiteley. Kobe Heron. Karen Burton. Karen Sue Burton. Holly Mormon. Julian Bahina. Julian Martin Bahina. Taylor Godfrey. John Howell. Mr. Howell, if you'll come back and meet with probation before I call your case, please, sir. Oh, you've already met? All right. She says she's already met with you. Didn't we just sign something?
Yeah. So I'm just waiting to see what the, I guess what we're doing is giving credit for this time, so. That's what I'm guessing.
Okay, so he's supposed to be well. Why was not?
That's
Why? So I'll
I'll just charge this.
I'll,
For sure.
yeah, maybe just show it. Christian Pritchett. Marcus Fowler. Janice Alkaline. Thank you, Mr. White.
So it's like she didn't just make a payment. She must have. So it's now.
2018, it's paid about 5,000. And then it's 3 years. So that was paid. CR 13-472, Michael Sanders. Mr. Sanders, if you'll come to the podium. Just come to that podium right there. Mr. Sanders, you're set today for a status hearing regarding the restitution payments or lack thereof on your community supervision. I do see where you paid a substantial amount on the 8th. I do see that. My concern is the 3 years prior to that, there were no payments.
Yes, sir, Your Honor, I was incarcerated part of
From-
federal prison after that, only in February.
February, well, let's, just because I don't know all the details of your case, tell me when you went into federal custody between July of 2018 and today.
On January of 2018. I'm sorry, February of 2019. Your Honor, about 2000, November of 2019.
So from February of 19 to November of 19, you're in federal prison.
Yes, in Springfield, Missouri.
What's the plan going forward on how we're going to pay off your restitution consistently rather than waiting for a year or 2 years to make a large payment?
Your Honor, I lost my job during COVID, and I've gotten another job back. I've been working, the night shift and all that. And, it's just been rough. And I feel it's my old daughter, I do the same thing for her kids. So we're having based on the daycare and all that, and the CPS is involved. And, you know, Andre, it's just tough. I mean, right now, it's tough. I'll do what I can do. I promise you that.
What do you think you're going to be able to do?
I mean, I think 500 a day on it and then just pay it every month as much as I can.
Well, I know, I'm really thinking more about what is your plan for monthly payments? Because here's the perspective that your probation officer gets. If there's no payments to restitution, and I understand being in custody, that time period, I understand that, all right? But from the perspective of your probation officer, if there's no restitution being paid consistently every month, even if it's a small amount, even if it fluctuates or varies due to losing your job or not, or it being seasonal work or whatever, if there's not a consistent effort, it looks like a lack of effort on your part to pay. So you know your budget, you know what you can and can't do. What do you think? What are you telling your probation officer is going to be what you believe you can pay each month to repay the victims in your case?
And, you know, I want to explain also, when I got out, I had a bunch of cases in Arkansas, which I had to take all that off, not to turn back to the one started all over. I have all that paid off. And my federal probation, totally turned on that. And now I can start working on this case. I can guarantee you 500 a month right now, for sure.
Well, I don't want to be the last one to the party.
Right. Well, and what I was trying to do, maybe it was wrong on my part, I was trying to get all that stuff done where I could commute, where I could just solely focus on this. I'm off federal probation in November of this year. That's my last deal. And then I have you guys, and then I can go. And I mean, I starting next month, I can pay 500, and I can pay 500.
Okay. I want you to know that you have my attention on your case. So I want to make sure that you're giving your full attention to what you're required to do. All right. So we've met today. You understand that I'm looking over the case. I'm paying attention. I know when you're paying. I know when you're not paying. So if I'm going to give it attention, in your best interest to be giving it attention also. Okay.
And I want to clarify something. I guess I need to talk to my probation officer about it. When I transferred to Arkansas originally, I didn't have to pay Vince and probation fees because I live in Montgomery County. And my probation officer in Montgomery County told me that I had to pay probation fees to Vince County. So I guess I'll get with Mr. Liddell and talk to him to clarify whether I do or I don't. Because I have probation fees in Montgomery County, drug test on it. Then I have, I need to find out if I need to pay probationary fees here through Vincennes County also.
Okay. All right. So I want you to go ahead and meet with Mr. Waddell today and y'all have those discussions and then he'll let me know if we need to have another court hearing. Okay. All right. You can come on around this way. Mr. Pritchett, CR 19-153. State, is there an agreement with regards to Mr. Pritchett? I know that, Mr. Pritchett, are you aware that Mr. Weiner won't be here today? Okay. Of course, aware of that also. Is it my understanding that there's some kind of agreement on Mr. Pritchett?
Yes, Your Honor, the state was going to agree to withdraw their motion to adjudicate in exchange for Mr. Pritchett finding an amendment to conditions of probation, basically getting back time, which is approximately 65 days. But because Mr. Weiner's not here, if we want to just reset that, I don't know. Mr. Weiner and I didn't have an agreement as to whether we're going to proceed with that today or just reset it completely with him not being here.
Let's just reset so that Mr. Weiner can be here for Mr. Pritchett. Yeah, thank you, sir. Man. All right, Mr. Pritchett, I'm going to have you sign this form. We're going to reset your case till June 15th to give Mr. Weiner time to be here to work out your case. And Mr. Pritchett, I want you to check in with probation this morning before you leave, okay? And for the record, CR 16139, State versus Holly Elise Mormon. It's my understanding through Mr. Weiner that Miss Mormon is in a rehabilitation facility. Is that correct? Any objection from the state to reset till June 15th? All right. Mr. White, Mr. Schmidt, ready on anything? Mr. Schmidt? Mr. Howell? John Williams, CR 19142. Is this a plea today?
We were sitting here, we were pleased with how it's been on the trial document for completely. We still have a living parent who's a logistical issue. We has agreed to statements about it. So we're going to basically pass on this set of file downstairs, leave below court, and then get from there. I do believe Mr. Howell is still on the trial document. 17, but I'm hoping that we can resolve this downstairs. We still have a grant, just not through.
Okay, so he'll remain on the trial docket, and then if you get the case resolved downstairs, we'll have a motion to dismiss up here.
Yes, sir, that's my.
Okay. All right, so this being a police setting, I'm not going to reset it. Mr. Howell, you're ordered to report back on Monday, April 17th at 8:30, unless your case gets resolved and dismissed before then. All right. May 17th. May. Mr. Ashmore, are you ready?
Yes, Judge.
All right, I'm gonna go ahead and call Kobe Heron, CR 18-263. Mr. Heron is set today on a motion to revoke. Mr. Ashmore, go ahead.
Hey, good morning, Judge. I was told by Ms. Tabram yesterday that Cody was reappointed to me on this motion to revoke, and I have a mediation starting at 10, so I asked the court's permission to appear by Zoom. I have spoken to Cody. We're asking the court for a short reset so I can talk about the case with the district attorney's office. I don't think we're going to need a lot of time, and that way we have a little bit of time to prepare for whatever plea negotiations or whatever we may need to do if there's going to be some sort of hearing.
Any objection from the stage? This is the first setting on motion to revoke.
The first setting, we did not know that Mr. Ashburn, MTR discovery, Mr. Ashburn was not have an objection to resetting. So we can review that with Mr. Herring and then negotiate a possible resolution.
All right, we're pretty full for May already, so next available is going to be either, how about June 15th? Are you available on June 15th, Mr. Ashmore?
I think I'm already there, Judge. Let me pull my calendar and double check. Just a moment, please. Unfortunately, no, Your Honor. Is the 8th at any way available?
No, sir. What about June 17th? Are you in trial that week?
No, we're trying to take a family vacation that week.
All right, I'll tell you what I'll do.
May 25 unavailable.
We're already pretty maxed on the 20. I'll tell you, I can put it on May 25th if you think you can be ready on the 25th.
I can be ready on the 25th. It's an MTR, and that'll give us almost a month. That's I believe a sufficient time.
All right, Mr. Herring, the court's going to reset you for another hearing on your motion to revoke to May 25th at 9 a.m. So I'm going to have your client sign a notice of appearance, and then I'm going to let him go. So if you need to get off to go ahead and prepare for your mediation, you're free to do so, Mr. Ashmore.
Thank you, Judge, and thanks again for the accommodation this morning.
Yes, sir.
All right, y'all have a great day.
You as well. All right, Mr. Herring, I'm going to have you sign this forms. Got today's date, and it says the reset date is going to be May 25th at 9 a.m. Okay. Joe, could you help me out here?
Yes, sir.
Do we know if Mr. Green and Ms. Burton are coming today?
Judge, we've had no communication.
Is Karen Sue Burton here? Is April Grant? And I believe Mr. Parrish is here meeting with Mr. Godfrey, and that's going to be a plea, correct? And then we're just waiting on paperwork from Mr. White and Mr. Fowler. Okay. All right, court call CR 20337, State of Texas versus Taylor Godfrey. Mr. Godfrey, if you'll come to the podium. Mr. Godfrey, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? You can put your hand down. All right, you are Taylor Lath Godfrey, is that correct? And Mr. Godfrey, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? Okay. And you are represented by your attorney, Mr. Jason Parrish. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and have all of your questions answered? Is there anything, Mr. Godfrey, about the paperwork that you've read and signed with Mr. Parrish's counsel that you do not understand? And Mr. Parrish, do you believe that Mr. Godfrey is competent today?
He is.
And you explained to him his legal and constitutional rights and also the benefits and disadvantages of a deferred adjudication plea?
I have one.
And you believe he understands all of those?
Yes, sir.
Mr. Godfrey, you are charged by indictment with a third-degree felony offense of possession of controlled substance in penalty group 2 greater than or equal to 1 gram, but less than 4 grams. That carries a range of punishment of not less than 2 years or more than 10 years confinement in TDC and a fine not to exceed $10,000. Do you understand that full range of punishment? I see here that you want to, in your agreement with the state, to plead guilty to that charge in exchange for the state's recommendation that the court defer a finding of guilt in your case and place you on 3 years community supervision. You'd also have a fine, restitution, court costs, reimbursement fees, and the state would be dismissing a filed marijuana case. Is that your understanding of the plea agreement?
Yes, sir.
Do you understand that if the court approves this and places you on deferred community supervision, that if you violate the terms and conditions of that community supervision and the state files a motion to adjudicate your guilt, the court could conduct a hearing and if satisfied by the evidence, could convict you of this offense and could revoke your community supervision and assess your punishment anywhere between 2 years and 10 years? You understand the court would have the full range of punishment at its disposal.
Yes, sir.
Knowing those things, do you still want to go forward with this plea? Mr. Godfrey, then to the charge of possession of a controlled substance in penalty group 2, greater than or equal to 1 gram, but less than 4 grams, how do you plead?
Guilty, Your Honor.
And are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or influenced you in any way to make you believe that you had to plead guilty to that charge?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Parrish, any objection to states one?
No, Your Honor.
States one's admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Just a slight clarification, Mr. Godfrey is under indictment for a second-degree felony from 4 to 200. We are agreeing to proceed under a lesser included amount of 1 level. In accordance with the state agreement, we will give them all proper attention. They were rushed to close.
Thank you, Ms. Heisel. Anything further from the defense?
No, Your Honor, you have, there's one other collateral matter. Class C citations issued, and the state's going to dismiss those class Cs. Well, it's not in the judgment, it is contained in the paperwork, but we have no issues with those, the agreement to dismiss those class Cs, not in the judgment.
That's correct, Your Honor. We're going to have to
Okay, court will take a moment to review the evidence. All right, based on the court's review of the evidence, I find that there is sufficient evidence to convict the defendant of this offense. However, the court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Godfrey on 3 years community supervision, assesses a $1,500 fine, orders restitution of $180, court cost of $290, and reimbursement fees of $35. The court also finds that DA 2020-212 will be taken into consideration under section 1245 of the Texas Penal Code. Mr. Parrish, I'm going to need your client to sign the trial court certification of appeal. Thanks, sir. All right, Mr. Godfrey, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward to be fingerprinted with the bailiff. After that, I want you to report to the probation department, okay?
Thank you very much, Your Honor.
Thank you, Mr. Parrish.
Good seeing you.
Good seeing you. It's good to be seen in person. Mr. White, are you ready?
Yes, sir.
Oh, he was just kind of. Yes, ma'am. Ms. Alkalan. All right, this is cause numbers 2018-433, 2019-140, CR 2376, State of Texas versus Janice Marie Alkalan. Ms. Alkalan, if you'll raise your right hand, I'll place you on oath, ma'am. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Make sure you speak up as loud as you can, okay, so my court reporter can hear you. Ms. Alkalan, you have 3 cases today, and it's my understanding that you're going to be pleading on 1 case and 2 cases are going to be dismissed. It appears that on your probation case, you're going to be pleading true to some counts in the state's motion to revoke in exchange for the recommendation that your probation be revoked, sentence assessed at 14 days confinement in the county jail with you receiving credit for 4 days, being ordered to pay the balance of your financial obligations with you having to submit to the Van Zandt County Jail on Monday, May 3rd by 7 p.m. to serve your remaining jail sentence. Is that the plea agreement that you've worked out with the state?
Yes, sir.
And that's what you want the court to approve today?
Yes, sir.
And you understand if the court approves this and you do not appear on May 3rd, that an additional charge could be brought against you.
Yes, sir.
All right, Ms. Alkalan, it appears that you came before the court on August 7th of 2019 on the charge of assault causes bodily injury, Class A misdemeanor. Court heard the evidence, found that there was sufficient evidence to convict you. The court did convict you of that charge, assessed your punishment at 1 year confinement in the Van Zandt County Jail. However, the court suspended that sentence and placed you on probation for a period of 18 months. It was during that term that the state filed its amended motion to revoke and included 2 counts. Have you had an opportunity to review that motion with your attorney, Mr. White?
Yes, sir.
Mr. White, does your client waive the formal reading of the state's motion?
Your Honor, we wait for the state's motion. It's our intention that we're going to plead count 2 true, and I would state it's one to abandon count 1.
That's correct, Your Honor.
Okay. All right, Ms. Alkalan, you're represented in this case by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Feel like you've had enough time to meet with him and discuss your cases and have all your legal questions answered? Anything about the paperwork today of the plea agreement that you do not understand? All right, Ms. Alkalan, then to count 2 as contained in the state's amended motion to revoke, how do you plead to that count? True or not true?
Sure.
And are you pleading true to that count because that count is true and for no other reason? Has anyone threatened or forced or pressured you to plead true?
No, sir.
All right, the court will accept the defendant's plea of true to count 2. Mr. White, any objection to the admission of the defendant's waiver of rights and plea of true as State's Exhibit A? State's Exhibit A is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense? All right, based on your plea of true and the evidence before the court, Ms. Alkalan, I'm going to find that you have violated the conditions of your community supervision in the court finding that count 2 to be true. The court on that finding hereby revokes your community supervision, assesses your punishment at 14 days confinement in the Van Zandt County Jail. Court will award you 4 days credit towards that sentence for time already served. Court orders you to pay the balance of your financial obligations. Court also orders you to submit yourself to the Van Zandt County Jail on Monday, May 3rd, 2021, no later than 7 p.m. to serve the remaining jail sentence in this case.
She needs to appear at the jail by that time, and she can say, I'll get her out of the home. They'll let her in and open.
Thank you, Mr. White. All that's very much true, Ms. Alkalan. If you don't do any of those things that Mr. White told you that you need to do, then the jail is going to turn you away, and it's going to create additional problems for you. All right, Ms. Alkalan, you hereby remanded to the custody of the Van Zandt County Sheriff so you can carry out the terms and conditions of your sentence. I'm gonna have you step forward to be fingerprinted with the bailiff, and you should stick around and get a copy of this so that you can use it when you turn yourself in on Monday, May 3rd. Let's go with that. All right, Mr. Schmidt, Mr. Wiley. So CR 1934, State versus Nathaniel Dean Whiteley, set on a hearing today. Motion to revoke. Court set this for Mr. Whiteley to hire an attorney. Mr. Schmidt, have you been retained to represent Mr. Whiteley?
Yes, sir, Judge, I've been saying today on this Friday.
All right, I will enter you as counsel of record, and we will reset Mr. Whiteley to give you time to get familiar with the case. I believe June 15th is the date that I have available. Or you have any scheduling issues that day?
I do, and I've been meaning to get that in my vacation, but I'm out of town. Oh, I have to pay her bill. I like bells.
Answer that.
So what I'm gonna do, I'm gonna set Mr. Wiley for the contested docket on June 29th. I'm gonna set it that far out rather than a 30-day setting and then an additional contested setting if needed. I'm just gonna go ahead and set it for contested hearing in 60 days. And that's more than enough time to work out the case. If not, then we'll just hear it on the 29th. All right, Mr. Wiley, let me remind you, you're still on probation. Still required to report, comply with all your conditions. Just because a motion's been filed doesn't mean you can go out, drink, smoke marijuana, do whatever you want. You understand? All right. Yes, you're excused. Mr. White, are you ready? All right, Mr. Fowler. All right, Mr. Fowler, if you'll raise your right hand, sir. Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. You are Marcus Anthony Fowler.
Yes, sir.
Mr. Fowler, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed and treated with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to have your case discussed with him to answer all of your legal questions?
Yes, sir.
Is there anything about the paperwork that you've reviewed and signed today that you do not understand? You hesitate a little bit. Is there a question?
Thank you.
Okay. Mr. White, do you believe Mr. Fowler to be competent today?
Yes, Your Honor.
And you've explained to him his legal and constitutional rights?
I have.
Mr. Fowler, in CR 2160, you are charged by indictment with a third-degree felony offense of injury to a child, elderly, or disabled individual with intent to cause bodily injury. However, it appears to the court that the plea agreement in your case is for you to plead guilty to a lesser included offense of assault causes bodily injury, family member, family violence, which is a Class A misdemeanor, with the recommendation being 10 days confinement in the county jail with credit for 4 days, a $1,600 fine, with the state dismissing CR 2159, your other charge also of injury to an elderly child or disabled. In addition, you would have court costs and reimbursement fees. Is this your understanding of the plea agreement today?
Yes, sir.
And this is what you're asking the court to approve?
Yes, sir.
I see as part of this agreement, the state's recommending to the court that you be allowed to serve your jail punishment on separate dates beginning May 15th. Looks like these are weekend commits. You understand that if the court approves these and you do not show up and report like you're supposed to, that it could result in an additional charge? Understanding all of those things, Mr. Fowler, I have to tell you that the range of punishment for a Class A misdemeanor assault causes bodily injury family member is confinement in the county jail for a period not to exceed 365 days or a fine to exceed $4,000. Do you understand the full range of punishment? Understanding that, how do you plead to the Class A misdemeanor offense of assault causes bodily injury of a family member? How do you plead? Guilty or not guilty? And are you pleading guilty because you were guilty of that offense? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to states one?
No, Your Honor.
States one's admitted into evidence and the court takes judicial notice of Mr. Fowler's judicial confession. Anything further from the state?
No, Your Honor, state would, state we are in compliance with the notification and not receive anything back from them. We are in compliance.
And is the family member a child? Is it a spouse? Is it, what is it?
I believe this is Ms. Tyson's case. My understanding is Mr. Fowler's child, who is, I believe, 13, 14, something of that nature.
Teenage.
All right, anything further from the defense? Mr. Woodwalk, I'm gonna need the state to sign the admission of unadjudicated, the 1245. All right, Mr. Fowler, based on the court's review of the evidence, I'm going to find that there is sufficient evidence to convict you of this offense. The court does convict you of the Class A misdemeanor offense of assault causes bodily injury of a family member involving family violence. The court assesses your punishment at 10 days confinement in the county jail. The court awards you 4 days credit towards your sentence, orders you to pay a fine of $1,600, court costs of $270, and orders you to pay a reimbursement fee of $65. Court's going to order you to serve the remainder of your sentence by submitting yourself to the Van Zandt County Jail on Saturday, May 15th, 2021 by 6 p.m. with release on Monday, May 17th, 2021 by 6 a.m. And also likewise surrender on Saturday, May 22nd by 6 p.m. being released May 24th, that following Monday by 6 a.m. All right, and Mr. Fowler, is Mr. Fowler making arrangements to pay his financial obligations today? And Mr. Fowler, you understand if you don't pay your court costs and fine and reimbursement fee, the court will issue a warrant for your arrest? All right, so once you receive a copy of this today, I want you to report down at the end of the hallway here on the top floor and meet with Miss Bonnie LaPrade. All right, Mr. Fowler, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the bailiff. It's very important that when you submit yourself to the Van Zandt County Jail, that you bring with you a copy of this judgment and special order committing you to the jail. In addition, you will need a photo ID. Your failure to bring either one of those is going to result in the jail rejecting you, and then they're going to contact me. Okay. So I'll have you step forward with my bailiff. And I'm not sure if I mentioned it, but the court did see in the plea agreement that cause number CR 2159 was being taken into consideration under section 1245, and the court has signed that to stay. You put that with that.
Angels will get their wings. And one in once. Yeah. Really quick. So. Yeah, more crevices around. This thing.
They have, yeah. Yeah. that's
I
right.
love those things. I know I don't like snakes. Remember that. Yeah. Have a healthy respect for snakes. We'll call it that. I'm not afraid of snakes, but healthy respect. But, well, these walls, you know, these walls are just crevices and holes that.
A snake or a snake? And they were like, no, a snake.
All right, Mr. Bahina. If you'll go to the podium, just come right out here in the front, right here. Court call CR 18456, State of Texas versus Julian Martin Bahina. Mr. Bahina, you are set today on a hearing on your motion to revoke. Are you going to hire someone to represent you, Mr. Bahina?
Well, when I was in jail, I filled out the 2020, but I don't think it really got that.
But you filled out one today. You filled out one today.
I mean, if it's serious, do I need to hire?
Do you think it's serious?
I mean, if it's serious,
You don't know that it's serious right now?
that's what I'm saying, like, you think it's ready to hire?
I'm going to tell you that you are on probation for a state jail felony offense of theft of property, which carries a range of punishment of not less than 6 months or more than 2 years in prison.
Yeah,
It's very serious. It's very serious. And you're on conditions of community supervision that say that you're not to have alcohol, you're not to be consuming substances. And Mr. Gann, I asked that the probation department administer a urinalysis test to Mr. Bahina today. Did you do that?
Yes, sir.
And what was the results of that?
He's positive for marijuana and alcohol.
Did you have any discussions with Mr. Bahina about that?
After he tested positive, he admitted to drinking a beer last night. He spoke to me on the 17th and 20th this month.
Today's the 29th. Mr. Bahina, isn't it true that you just recently got arrested for violating your probation conditions?
that's why I told you, I was like, I just feel like I was good. It's still $1 million. I was just like, I'm not gonna do it once. I'm gonna let you get like a week to get clean.
I'll give you a week to get clean because this is what I'm going to do, Mr. Bahina. I'm going to find your bond insufficient today, and I'm going to put you back in custody. Really? What do you think we're doing here? What do you think probations and conditions are about, Mr. Bahina? You came to court. I told you, no drinking alcohol, no smoking marijuana. It was a very bad decision. And with bad decisions come bad consequences. And this is a bad consequence. You posted a $50,000 surety bond to get out of jail. I'm finding that insufficient. I'm going to raise it to 75,000. Really? This is not a dream. This is reality, Mr. Bahina. How old are you? About to be 21. You're an adult. It's time to start acting like an adult. Well, you're going to have time sitting in the jail to think about it. So this is my advice to you. Whatever money you have, I would hire an attorney. Whatever money you have left, I wouldn't spend it on a bondsman to get out of jail. I'd hire an attorney who's going to help you out of this situation. Because apparently when you post bond and get out, you just go right back to doing what you want to do. And all it does is bring you back to court and put you right back in jail. So I know you're not going to do it because I'm going to put you in the jail. They don't let you drink in the jail. They don't let you smoke. You ought to be working on not losing your freedom, Mr. Bahina. Your job. I understand. You also got to quit drinking alcohol, quit smoking marijuana.
This whole 3 years that I've been on there, I haven't even smoked.
I'm not going to do it, Mr. Bahina.
Please
No. Deputy, if you'll go ahead and take Mr. Bahina into custody at this time. Court's found his bond insufficient. Court's setting new bail at $75,000.
So I get an attorney to try to get the case reinstated.
You need to hire an attorney and have them contact the DA's office so he or she can work on resolving your case. I don't know what all the allegations are in your motion to revoke, but apparently you've done more than just drink and do marijuana the last couple of days. That's how you ended up here in the first place.
Just because the reason I got the motion to vote is my dad is down on the phone.
Well, let's don't talk about that because anything you say could be used by the prosecutors here today. Okay. The prosecutors are behind you. All right. So when you get to jail, you need to reach out and you need to make contact with, you need to hire an attorney, and the attorney can file a motion to get you back out of jail. They could ask me to reduce your bond. They can speak with the state to try to work out your case. That's what you need to do. All right. So what I'm going to do is I'm going to set your case, your motion to revoke. I'm going to set it for contested hearing on June 29th. So you've got 2 months. You've got 2 months. I've given you a chance. I put you on probation. We looked each other eye to eye. Do you think I was playing around then? You're going to get a week sitting out there in the jail. They got phones. They got the mail. I'm not trying to mess up your life either, but you're the one that decided you're going to smoke marijuana and drink alcohol while you're on probation. You can be upset at me all you want. I'm not the one that brought you here today, Mr. Bahina. You are. And listen, it's time for you to grow up and take responsibility for your actions. I'm sorry that I'm the first one that's telling you that. But if that's what it's got to take, I think you are trying to mess up your record. Mr. Bahina, if you weren't trying to mess up your record, you wouldn't come into this courtroom having drank alcohol and smoked marijuana right when you got out of jail. Right when you got out of jail. I want you to just stop and listen. Quit talking. Just stop and listen. Hear what you're saying. I'm on probation. I get arrested. I go to jail. First thing I do when I get out, drink and smoke marijuana. Listen to that. Don't say anything else. There's nothing else to say. Just listen to that. And you don't want to mess up your life. Listen to what you're saying. Listen to the words. No, listen. Listen to what's coming out of your mouth. You're saying one thing, but it ain't making no sense to anybody in this courtroom. So I found your bond insufficient. You're going to go into custody today. Hire that attorney. The attorney comes back in here. We'll work on your case. May even consider letting you back out. You're gonna need to hire your own attorney, Mr. Bahina. Okay, thanks. I did. Let me give that to Mr. Bahina. Yes, I forgot about it. Yeah. He's here. Mr. Brown. All right, Mr. Brown, can you hear me now? I'm going to ask you to unmute your phone. I sent you a prompt.
Yes, sir. Can you hear me?
Yes. I apologize for the delay, Mr. Brown. I was in a hearing. This is cause number CR 1783. This is in the matter of a probation extension for Mr. Joshua Dwayne Brown. Mr. Brown, the probation department tells me that you need to extend your probation. Is that correct?
Yes, sir.
Can you tell me why?
Still have a little bit of community service to do, like 90 hours, I believe. And then like $300 to pay off.
Okay.
That's it.
Do you believe if I extend it, it will help you have enough time to take care of all of your conditions of probation so that there's not a motion to revoke filed?
Yes, sir. Absolutely.
Okay. All right. Court's going to find that Mr. Joshua Brown has intelligently, knowingly, and voluntarily consented to the extension of his community supervision. Court approves that and signs the probation extension today. You can get a copy of that from your probation officer next time you report. Okay.
Yes, sir.
All right. You're free to go, and I apologize for the delay.
Thank you, sir.
You too. Have a good day. Can I help you? What's your name? You're at 1:30, right? Yes, ma'am. And Mr. Green will be here at 1:30? Okay, yes. I think I called your name earlier today, and it was my mistake that I didn't have it reflected on my docket that you're at 1:30. So you're free to go and just come back at 1:30. Mr. Green should be here. So you at 1:30, are y'all zooming or y'all will be here? Okay. But you don't know about Mr. Green? Because he's set for evidentiary.
I understand, Judge.
Okay.
If necessary, I'll probably have to reset up.
Okay.
I don't anticipate.
Okay. See y'all 1:30. Boys think. Yeah.
During a jury trial, anticipate you cooperate